across the labor and employment world. And right now, especially here in Washington, D.C., there is no topic that is hotter than the Department of Labor. Seemingly every day there's a new executive order, there's a new potential repeal of an old executive order, and there's a whole heck of a lot going on here in D.C. So we thought it would be prudent to share our inside knowledge with you all on the line here and really let you know what is going on now, where that leaves us, where we were prior to the new administration, and more importantly, where we are headed to the best of our ability to predict, because in truthfulness, no one can really predict exactly what will happen, but based on everything we hear going on inside the Department of Labor, we have some good predictions for you about what you should be doing to prepare for the next year and all the various legislation that is coming down the pipe. As I said, my name is Jordan Schwartz. I'm a partner here in the Labor Employment Group. I focus on representing employers in all aspects of the employment relationship, both in litigation. I litigate on both the federal and state level and across all aspects of the panoply of employment laws, the Americans with Disability Act, the Fair Labor Standards Act, Title VII, the FMLA, affirmative action programs. I also counsel employers when we're not defending lawsuits on compliance with federal and state law, including issues relating to hiring, discipline, internal investigations, and termination. And finally, I also advise workplaces both in the unionized and unionized arena regarding employers' rights under the National Labor Relations Act. With me presenting this topic today is Dan Deacon, and I will let him introduce himself.
Hello, everyone. My name is Dan Deacon, and I am an associate here at Conn Maciel Carey. I represent employers during inspections and investigations conducted by federal and state OSHA. I also advise and counsel employers in responding to notices of safety complaints and OSHA citations, and I represent and advise employers in all aspects of the employer-employee relationship, including reviewing and revising employee handbooks and workplace policies and procedures. So with that, Jordan's going to go over the agenda, and we're going to get started with the meat of the presentation here.
Okay, thank you, Dan. One or two housekeeping matters that I failed to mention. First, this webinar is being recorded and will be available if requested. Second, we have muted everyone's lines. However, you should see a chat function at the bottom left of your screen, and you can ask questions. Feel free to ask questions throughout the presentation. We will try to address them during the presentation or at the end. If somehow we can't address them, you will see our contact information at the end, and you can always email us the questions. And Dan and I, love to interact with people on the line, and we'll be more than happy to answer any questions you might have and really discuss these issues further with you all. So, as I said, the agenda here is pretty simple. It's just what the heck is going on with the Department of Labor. What's the current legislation? Where are the executive orders coming from? What's going on with them? And really the big takeaway you'll get right away is how much of a major shift is happening in Washington and thus throughout the country right now, and how these executive agencies operate. So that'll take up the first half of the presentation. And then from there, we'll talk more just specifically about the Department of Labor and the potential other activities that may come from the Department of Labor. Just a little bit, we'll touch on the EEOC and what's going on there as that relates to all this major change in all these executive agencies. And even OSHA, we just want to touch on that and tell you what's going on now and how that is changing. In essence, the rules are different than they were just a few months ago, and we just want to make you at least cognizant of what's going on so you're better prepared to deal with any changes that will arise. So, as I said, this is really from day one in office, a historic shift in the executive agency occurred. Trump signed a number of executive orders fully designed to begin restructuring the way in which numerous regulatory agencies operate, and in particular, from our purposes, the Department of Labor. So that's really the most certain thing I'm going to be able to tell you right away, is that the way the agencies are functioning are now changing dramatically. One of the first acts of business, or possibly the first thing that President Trump did right when he took office, was the issuance of what's called the Priebus Memo. And what that says is that no new regulations can be published unless a Trump appointee personally approves it. It also says that regulations that Obama set forth that have not yet been published in the Federal Register should be immediately withdrawn, and that the effective date of other Obama regulations that have been published but that have not yet taken effect should be postponed for at least 60 days to allow the new administration to review questions of law and fact and policy and ensure that these regulations have the go-ahead from the Trump administration. So that was all on day one. Also, on day one, Executive Order, I believe the number is 13765, which the title is Minimizing the Economic Burden of the Affordable Care Act, which right away, as Trump promised in the campaign, really signaled the beginning of the end for Obamacare. The executive order didn't really change the law at that point and didn't even grant any governing agency the increased authority to repeal Obamacare. It was basically just a statement saying, don't worry, going ahead, the Affordable Care Act will be repealed and or revised. Another thing that happened right away is that Trump appointed temporary political appointees, and they actually even skipped inauguration to begin implementing the Trump agenda right from day one. And what they're doing, they're called beachheads, and they're essentially running the agencies until each of the secretaries and undersecretaries are appointed. And they report back to the Trump administration about what is going on in each respective agency. And finally, right from the outset, Trump made sure that everyone knew that he would be proposing a budget cut, which is approximately $2.5 billion for the Department of Labor. And Dan and I will both discuss that a little bit more later about what exactly that entails. But, basically by January 20th, a lot of these initiatives were already in order, and there was a clear indication of what was to come. And one of these executive orders that had been discussed for a while and finally I believe it was just about a week ago that has been implemented is called the Comprehensive Plan for Reorganizing the Executive Branch. And as you see on the slide, the goal is really to improve the efficiency of the government, and specifically the executive branch. And the way the executive order directs this to be done is that the director of the OMB, the Office of Management and Budget, is set to propose a plan to reorganize governmental functions and eliminate unnecessary agencies, components of agencies, and agency programs. So if the director of the OMB finds that some of these functions are redundant, they will be eliminated. Also, if the cost of continuing to operate an agency does not seem to be justified by the public benefits it provides, or if the cost of shutting down seems to be not as high as as the director otherwise thinks it is, the agencies may in fact be shut down. So for your purposes, one question you might be thinking, so as an employer, what does this mean for us? And the big thing is there's an opportunity for you all as employers to really help shape the executive branch by submitting comments. There will be public comments that will be invited before in front of the director of the OMB, so they can consider what members of the general public are thinking and what they want to see happen. So if there are certain, based on your industry, if there are certain programs that you think are specifically useful or are not specifically useful, you will have the opportunities to submit public comments on behalf of your organization, or have your counsel submit public comments on your behalf and potentially shape the executive branch going forward. So that this is something that's pretty unique, that really has not happened before. There also has been several executive orders aimed at really slashing and cutting government regulation. One that most of you are probably aware of is EE 13771, which requires that for every new rule promulgated, an agency must eliminate 2 regulations. And it's a little tricky here because the order does not require the repeal of the regulations to be concurrent with the publication of new regulations. So there's no real set order of if the repeal has to happen first or if the new regulation has to happen first. And there's even a difficulty in determining how the costs are assessed and who determines the cost. But for the most part, the Trump administration really seems pretty darn serious in enforcing this regulation to eliminate what they term is the excess of current regulations. So it'll be real interesting to see how this is implemented, but it'll be very difficult for new regulations to be actually implemented without other regulations similarly being deleted. The other executive order that is somewhat similar to this is EEO 13777, which directs the head of every agency to designate an agency official as its something called the Regulatory Reform Officer. And what this person must do is oversee the implementation of regulatory reform initiatives and policies to ensure that agencies effectively carry out these reforms. And in addition to that, not only is there a reform officer that's required based on this executive order, there's also a whole task force that will be required with other designated agency officials. And what they will be tasked to do will be to evaluate existing regulations and basically make recommendations regarding which ones should be repealed, which ones should be replaced, and which regulations should be modified. So it's really just another way to kind of streamline and whittle down what the Trump administration believes is just too much excess right now and too much fluff, for lack of a better word, in a lot of these agencies. So again, what I always like to do is, after explaining what's going on, come back to the more important question for your purposes, is how do these actions affect you as an employer? And the thing that you want to keep in mind is that this is now a pro-employer administration. The previous administration was certainly known as a pro-employee administration and set forth millions of dollars to be headed to the Department of Labor so that they had more investigators, more investigations, and really were known as an extremely enforcement-heavy Department of Labor. Here, the administration seems to be focusing more on restructuring the DOL so it assists employers rather than harshly penalizes them. There will still be enforcement, but it's almost guaranteed that there will be, given the money involved, that there will be a decrease in enforcement and what seems to be an increase in collaboration and assistance with complying with the various laws, all the various different labor laws. So the other thing is how do these actions affect you by all the rules and regulations that were either set forth last year or attempted to set forth now have kind of hit a roadblock, so to speak. And some of the rules I'm talking about, I listed here on the slide: the Persuader Rule, the Overtime Rule, and the Fair Pay and Safe Workplace Rule. As of a year ago, I was fairly certain all those rules would be part of employer requirements day in and day out by now, and as I'll explain in a minute, it is more likely than not that none of these rules will be at least the way they were originally written, and possibly will not be in effect in any way, shape, or form. Real quickly, the Persuader Rule isn't quite as well known as, let's say, the Overtime Rule. So I just wanted to let you know what it was first. It required employers and their consultants to report when consultants, quote-unquote, persuaded workers. And the rule was supposed to expand the information which was supposed to be disclosed by employers and their consultants related to activities intended to discuss with employees their rights to certain union representation and collective bargaining. The purpose of that was to give workers the information they needed to decide how to exercise their voice and cast their votes. What happened, of course, was that an injunction was granted by the Northern District of Texas in November, putting the Persuader Rule on hold. What the injunction said was, you know what, the rule frustrates attorney-client privilege. It may even violate free speech. It's somewhat vague. It didn't really properly calculate the cost of regulation, and the DOL lacks statutory authority to enforce it. That's still where we are right now. We're still not sure what's going to happen. In early January, when the Obama administration was still in charge, the Department of Labor appealed this decision to the Fifth Circuit. Since then, since Trump has taken over, he has not done anything with this rule. He has not requested a stay. He has not really made any statements about his position. But the smart money is on the fact that the DOL will likely drop the appeal, or at the very least, this will be a rule that will be targeted by the administration once Secretary Acosta is appointed. And I'm going to go out on a limb here and say he will be appointed, and that this could be one of those Obama regulations that fairly quickly is abolished. The other rule that is almost in all likelihood being abolished right now is what's called the Fair Pay and Safe Workplace Rule. And what that was again, issued last year and was scheduled to be phased in over time beginning this year. And what that rule would have done would have imposed arguably burdensome reporting and disclosure obligations on companies that were bidding for future federal contracts. However, also in the Eastern District of Texas this time, a nationwide preliminary injunction was issued in October. And then under the Congressional Review Act, which, as you may know, is an act which allows Congress to undo certain recent executive regulations, the House and the Senate both voted to strike down these regulations, which was also known as a blacklisting rule. So right now we're only waiting for Trump to sign the order that basically eliminates this rule. But between you and me and everyone listening here, this rule is as good as dead. And that's good news for contractors and subcontractors that are not now subject to these much more burdensome reporting and disclosure obligations than they otherwise would be. Finally, there's the proposed FLSA overtime rule, which I assume most people on this webinar are fairly familiar with, which would have increased the minimum thresholds for an employee to be considered exempt from the overtime requirements. It would have doubled it from a little over $23,000 to a little bit over $47,476. The estimates were that this would have brought 4.2 million workers into non-exempt status. And the other interesting thing with this rule is that it actually would have been continuously updated and every 3 years to continue to essentially have the minimum threshold compliant, change so that the number didn't get outdated, like many people feel that the $23,000 number is outdated now. But what's happened here, as you may know, is in, I believe it was November, right before the regulations were set to go into effect, a nationwide injunction was entered, and it was, once as with these other rules that I've mentioned, it was put on hold. And since then, there have been, some appeals. It's been appealed to the Fifth Circuit. There's been a stay. No one really knows exactly what's going to happen. And it's interesting from Trump's perspective that he's in the difficult position of backing his party, who do not really appreciate this rule, but also potentially alienating the working class voters who elected him to power, who really may stand to benefit from this rule. So there's kind of a give and take there from Trump's perspective. So there's no real guarantee as to what will happen because there has been no announcement on how this will proceed, at least from the agency perspective. But what is likely is that the rule will be negated in some way, shape, or form, either by the judge ruling on the motion for summary judgment, or Trump instructing the DOL to drop the case, or the DOL just repealing the rule. And there's some chatter going on right now about, instead of just dropping the rule, that potentially the rule will just be revised and potentially to a lower threshold. The number I've heard thrown out is somewhere around $35,000. $35,000 per year. So really in between the 23 and 47,000 number. And Acosta, Alexander Acosta, who is actually being the confirmation process is going on as we speak. He hasn't really made any comments one way or the other, so it's not really clear from an outsider perspective of which way he'll lean. It is fairly clear that Acosta is a little bit less aggressive than the former nominee of Andy Puzder. And on that note, that's why some people think the regulation might actually be amended instead of just completely stricken, as people thought would happen with Andy Puzder. But if Alexander Acosta does, and sorry, I shouldn't say amended. Basically, if he sets forth a new regulation that sets forth a new number, then all of a sudden he would have to issue a notice of the proposed rule. Then there would be public comments. Then it would have to be official. So this isn't anything that's going to happen in the near future. Any new rule would have to go through the entire rulemaking process again, and I wouldn't really hold your breath on a new rule being promulgated super quickly. But if there's one thing this administration has showed us is, you can never be certain, and you kind of do have to expect the unexpected. Also, I wanted to just set forth a few other potential executive actions that now may be on the chopping block. President Obama really did set forth a decent amount of executive orders, 27 to be exact, that focused on the workplace or different actions that benefited minorities, younger workers, and underserved communities among federal contractors and employees. And for example, the federal contractor disclosure of past labor law violations, as I already explained, which is kind of doomed already, just pending President Trump's signature. But other ones are that President Obama, or former President Obama, raised the minimum wage for federal contractors to $10.10 per hour. But a lot, from what I hear, there's a very good chance that this may be voided by President Trump. Also, former President Obama established paid sick leave for federal contractors. I believe covered employees had up to 7 days of paid sick leave annually, and that even included paid leave allowing for family care. But it's very likely that this executive order also may be voided by President Trump. Right now, those are the laws, and you do need to abide by them, but just you really need to be cognizant of what's going on in the news, so that you, as a representative of your company, you make sure to comply with the potential new laws if these executive orders are voided. And now I want to just talk for about 2 more minutes before I turn this over to Dan, just about a few other issues that are going on with what we're calling the revamped Department of Labor, what the new agenda is, and steps that you want to take to stay ahead for 2017 and beyond. The first, as I mentioned, just so you know what's going on right now, is Alexander Acosta is going through the confirmation process. And as I mentioned, his views on these pressing issues in the DOL, like the overtime rule, are largely unknown, but he's been much more really mainstream. Both employees and employers neither one seem to have much of a problem with him. He has not been an outspoken critic of minimum wage increase or even paid sick leave policies. This is in stark contrast to Andy Puzder. So it'll be really interesting to see where he goes, assuming his nomination is confirmed. And this is more of almost an curiosity. He's done such a good job of keeping his views kind of close to his vest that even the articles today discussing his what was going to happen in his confirmation hearing, no experts really seem to have a good idea of what he'll be asked, given that he doesn't have any many controversial statements, as opposed to Puzder, who had just a plethora of controversial statements prior to the withdrawing of his nomination. And the other thing I just wanted to explain a little bit more, I had mentioned it earlier, that there is now a proposed budget cut for the Department of Labor of $2.5 billion. I believe the slide here, the title says million, but it is actually $billion. And that scales back Department of Labor funding by almost a quarter, which is really, really unbelievable. And some programs that will be impacted are the Senior Community Service Employment Program, which is a job training program for low-income seniors, the underperforming job corporation centers will be impacted, certainly OSHA training grants, and we've seen from my partners here in the OSHA, who focus more on OSHA issues than I do, the effect that this is already having on workplace investigations. And even the Office of Disability Employment Policy, which promotes policies to help disabled individuals succeed in the workplace, that is also going to be losing technical assistance grants. And it will completely eliminate funding for the Chemical Safety Board, which again also impacts OSHA. There is an increase in funding for the Reemployment and Eligibility Assessments Program, and that is the purpose of that, interestingly enough, is to root out fraudulent unemployment insurance claims. So what you should expect from the Department of Labor now going forward is more assistance with compliance than there otherwise was. More opportunities for you as an employer to come into compliance before enforcement actions are pursued, and more outreach and attempts to assist employers, and particularly small employers who might not have the ability to obtain counsel. The acting solicitor right now, Nicholas Gale, is very, for lack of a better word, pro-small employer. Many of his comments talk about his desire to help small employers and make sure that they have the at least knowledge and or resources available so they can comply with Department of Labor rules and regulations. So it's interesting. So this means fewer investigations and enforcement actions, but what I'm going to mention on the next slide, that doesn't mean you don't have to be careful. I'll get to that in 1 second. More time to bring your company into compliance, and hopefully friendlier interactions with the Department of Labor, that are a little bit less adversarial in nature. But as employers here, I don't want you to misconstrue what I'm saying and think that you need to be less vigilant about, ensuring compliance with anything, whether it's OSHA, wage and hour, or other DOL rules. Notwithstanding these cuts, the DOL under the last Republican administration still enforced the law plenty. It's not as if the law isn't enforced. And what the Bush era did, which could potentially happen now, is utilize something more akin to a poster child enforcement philosophy, across various agencies. So although maybe there are fewer overall inspections, some of the enforcement actions may be more substantial, and they can use a single employer as an example to others. So this doesn't mean that we can just get off scot-free and not pay overtime or do anything else that would potentially be considered a violation of the law. So as an employer, I really want you to continue to take proactive steps, conduct wage and hour audits of your wage payment practices for overtime purposes. I know we're not sure right now if the law is going to be $47,000, $23,000, or somewhere in between for the minimum threshold for exempt purposes, but you still should be prepared for whatever the rule is whenever it does get announced. I still want you to conduct safety and health audits to identify any compliance gaps that your organization might have. These precautionary steps really will significantly limit the chances of an enforcement action and could help facilitate resolution of any inquiries from the government. And that's really especially helpful, given this anticipated shift towards a DOL that wants to be focused on compliance and wants to help and work with employers to essentially help you remedy your practices instead of just wanting to penalize them. Employers also, as I mentioned here in one of these bullet slides here, it's still always important to review your employee handbook policies. Given the changes in law the past couple of years and, of course, the new changes that are happening now, both on a state and also, both on a federal and also on a state level, you want to evaluate your policies and make sure they're consistent with existing employment laws. I always recommend my clients have an employee handbook. However, there's an argument to be made that no employee handbook is better than an employee handbook that sets forth laws that are actually incorrect or policies that your employees should abide by that are contrary to what the law actually is. So you really need to be cognizant of the law and careful that your policies that your company sets forth abide by this law. And on that front, some of the other laws that just have been important, that have been thrown out the last couple of years as laws you want to be careful about, including all these wage and hour laws and all these DOL laws I've mentioned, are various social media policies, technology use policies, drug and alcohol policies, and the policies relating to the DOL, like leave policies, like minimum wage. You really just need to be aware of what's going on so that you are in compliance with the law. And with that being said, I'll be quiet for a few minutes here and actually let Dan talk for a little bit, but I'm sure I will pipe in here and there with some other ideas I have for you in the next little bit of the presentation.
Great, thanks, Jordan. So in addition to discussing what's going on with DOL today, we also want to just give you an overview of some other potential legislative and executive actions to watch closely in the future going forward. The first one being minimum wage law. So it's still unclear what Trump's stance is on the minimum wage at this stage. As far back as May 2016, he said minimum wage should be left to the states. A few months later, he said minimum wage should be $10 per hour, and a few months after that, he was saying wages are too high. Generally, though, this doesn't appear to be a high priority at the moment on Trump's agenda, so we probably won't hear much on this front soon. And although his stance has shifted, it's important to note that Vice President Pence, he's vigorously opposed an increase in minimum wage, both as a congressman and as a governor. He voted against the Fair Minimum Wage Act in 2007, which increased the minimum wage from $5.15 to $7.25. And as a governor, he signed the repeal of an 80-year-old state law that set a common wage for state construction projects, and he also signed a bill banning local minimum wage increases. So while it's not likely going to take place at the federal level in the short term, I just want to point out that it's critical for employers to pay close attention to state and local minimum wage laws, which seem to be changing rapidly. And I'm going to touch on that in more detail shortly. Another important item to keep a close eye on is pay equity issues. The political climate right now is ripe for some form of equal pay legislation at the federal level. Ensuring that employers provide equal pay for equal work, regardless of gender, it's traditionally been a priority of Democrats, while Republicans have historically favored paying the workforce and supported paying the workforce primarily based on merit with minimal government interference. And that's the position that seemed to hold true so far through the presidential election season, during the debates, speeches, and position papers that were released by both Trump and Hillary Clinton. However, during the Republican National Convention, interestingly, President Trump's daughter, Ivanka, offered a different message from the podium during her speech to delegates, stating that her father will fight for equal pay for equal work, and I will fight for this too, right alongside him. So we saw a very aggressive approach during the Obama administration on pay equity issues. So it's going to be interesting to see how Trump tackles pay equity issues going forward, and if he's willing to do so at all. However, this is another issue that has seen a lot of action on the state level, and given the significant emphasis on pay equity issues recently, employers, it would be wise to take a look at your compensation policies and practices, especially given that the new EEO1 report requirements to report pay data based on sex, race, and ethnicity should be ongoing right now during 2017. A couple other potential legislative and executive actions to watch closely, one of them being paid leave law. So Trump planned during the campaign, he promised 6 weeks paid maternity leave for mothers after childbirth. That was the plan he revealed back in September 2016. And this was significant because it was the first time a Republican presidential candidate made such a promise. Note, however, that it didn't extend to new fathers, parents who adopt, nor those who have children through surrogacy. And it was unclear whether it applied to single mothers either. More recently, however, in a speech to Congress in February 2017, Trump endorsed paid time off for both mothers and fathers, stating, "My administration wants to work with members in both parties to make child care accessible and affordable, to help ensure new parents have paid family leave, to invest in women's health, and to promote clean air and clean water." This is another area where we've also seen action at the state and local level, most notably in D.C., where employees will receive 8 weeks of paid time off for new parents, 6 weeks to workers caring for ailing family members, and 2 weeks of personal sick time. Activists have actually taken this fight to other states as well, and in total right now there's 4 states with paid leave laws, those being California, New Jersey, Rhode Island, and New York. So the Trump plan specifically is going to guarantee 6 weeks of paid maternity leave by amending the existing unemployment insurance that companies are required to carry, and the benefit would apply only when employers don't offer paid maternity leave, and it would be paid for by offsetting reductions to that program, so taxes aren't raised. Currently, though, it's uncertain how or when his plans will unfold, and it seems like it's being amended as we speak. But it's certainly a priority on his agenda, and we're just going to have to wait and see what kind of plan he proposes in the future. Currently, however, or simultaneously, Democrats and Republicans have both picked up on this issue on their own, introducing paid leave laws earlier this month. It's unlikely that either of these will pass, but now it's at the forefront of discussions, and it's probably going to be an issue that's going to be in the news for quite some time over the next few months. So Democrats on February 7th, just about a month and a half ago, introduced the Family and Medical Insurance Leave Act in both the House and Senate. The act would provide workers with up to 12 weeks of partial income when they take time off for their own serious health conditions, including pregnancy and childbirth recovery, the serious health condition of a child, parent, spouse, or domestic partner, the birth or adoption of a child, and or for particular military caregiving and leave purposes. It would entitle workers to earn up to approximately, I believe it's 66% of their monthly wages, up to a capped amount, and it applies to companies of all sizes, and including part-time workers. And that's going to be funded by small employee and employer payroll contributions of 0.2% of 1% each. So it's approximately 2 cents for every $10 in wages. Simultaneously, the Republicans, Senator Deb Fischer of Nebraska introduced a bill in the Senate on February 8th, a day after Democrats introduced their bills. It's titled the Strong Families Act, And it's essentially just a tax incentive, giving 25% of what employees are paid during the leave for businesses to offer 2 weeks of paid family leave a year. This bill has been introduced in the past, and it hasn't garnered much support by either party, so it's unlikely that this will gain traction again. Employers also need to pay particular close attention to state and local legislation on various issues that have not been addressed at the federal level. In light of the political climate right now, it's possible that other states are going to be taking these issues up on their own, some of which already have. And we'll begin with the state and local minimum wage laws. There's several state minimum wage laws that were implemented in 2016, raises that went into effect as of the new year. That includes just around us, New Jersey, Massachusetts, Connecticut, New York, and also California. Other state minimum wage rates are going to be increased later this year on July 1st, 2017, and that includes Maryland going up to $9.25, and the District of Columbia, where we are, going up to $12.50. It's also worth pointing out that there's a number of localities that have adopted minimum wages above their state minimum wage, which are set to increase this year as well. And that includes around us here in D.C., Prince George's County and Montgomery County, Maryland, the two neighboring counties surrounding Washington, D.C. So if you're an employer in the D.C. area, you alone could possibly have 4 or 5 different minimum wages that are applicable to your places of employment, depending on where you are, where you operate. Second, I'd like to just briefly touch on the overtime rules. A lot of state legislatures are beginning to contemplate overtime rules similar to the overtime rules proposed by DOL earlier this year. For example, the minimum salary threshold for the executive and administrative employee exemptions under New York law was $675 per week, or $35,100 per year. And as of December 21st, 2016, that threshold was raised as high as $825 per week, or $42,900 per year for employers of 11 or more that have 11 or more employees in New York City. That's different for other locales in New York. It's different for upstate, Nassau County. So it just depends. But the salary threshold in New York State was raised. Given that the federal overtime rules have been delayed, you have a little bit of breathing room right now with respect to that implementation, and you should consider using this time as an opportunity to examine state wage and hour laws and to ensure continued compliance with local requirements, and get ready for any increases in the minimum wage.
Let me just interrupt for 1 minute here. I just see someone asking a question about what we expect to happen with the EEO-1 reporting. And I know Dan had mentioned that a little bit. The latest information is that the deadline for reporting was extended by 6 months, I believe. And do we have a slide on that?
Yeah, I was going to briefly touch on that later. So the first reporting deadline is March 31st, 2018. So there's still time for changes to be made to that EEO-1 report. And there's likely going to be some reform, but as I'll touch on later, some of these issues are low priority right now for the new administration, and as nothing's firmly established at DOL, at the EEOC, it's difficult to estimate when those changes are going to happen.
So basically, yeah. So to answer your question, as an employer, you should, just continue collecting data for 2017 as you typically would, and ensure that your HRIS systems can organize the necessary information that you need, and you want to conduct internal pay analysis and determine if there are significant pay gaps based on sex, race, and or ethnicity, and that's really what you want to make sure to do. Okay, sorry to interrupt.
Oh no, perfect. Glad we addressed the question there. So back to the discussion here, we were regarding the overtime rules. The last point I want to make here is that employers need to make sure they're also meeting both the salary threshold set by the states in addition to the state duty requirements, which can be more restrictive than the FLSA. For example, in California, white-collar exemptions have both salary and duty criteria that are different from those under the FLSA. The duties test there requires a quantitative analysis, and an exempt employee must spend more than one-half of his or her time engaged in exempt work. So it's really important that you take a look at your state and local, the state overtime rules there as well. A couple other topics to be aware of on the state and local level are paid family leave laws. There's 5 states and the District of Columbia that have passed their own paid leave laws, including California, New Jersey, Rhode Island, Washington, and New York. And the payments typically come from a state insurance fund and aren't directly funded by employers, except in D.C., where it's supposed to be a 0.62% payroll tax on all D.C. businesses. However, recently, the D.C. City Council announced that it's going to be examining possible alternatives for the financing mechanism. So if you're an employer in D.C., you'll have to stay tuned for that, as they want to reduce the tax rate and lessen the burden on businesses. So they're going to be reviewing that, although it's currently in effect, or passed, but doesn't go into effect for at least a little over a year. Fourth, finally, you should pay close attention to paid sick leave laws. There's no federal law requiring employers to provide paid sick leave. However, as Jordan mentioned earlier, President Obama did issue an executive order requiring federal contractors to offer its employees paid sick leave. That's technically still on the books, but we don't know what's going to happen with that. However, states, on the other hand, have implemented paid sick leave laws that do apply to private sector employers. Those include just a few examples here: California, Connecticut, Washington, D.C., and Massachusetts. There's also several localities throughout the country that have paid sick leave laws as well. So you really got to take a close look at where you are and analyze those paid sick leave laws if they're applicable to you. For example, Montgomery County, Maryland, just outside of D.C. here, has a paid sick and safe leave law. We have a question here about the paid family leave for D.C. has not gotten into effect. That's correct. It was passed, but it's not going to be rolled out. It's phased in over, I think, the course of, it begins in 2018, 2019. So currently, the bill has been passed. They're revisiting it, but it's not technically.
Yeah, right now it's not technically in effect yet.
Right.
We only have a few minutes left, so Dan's going to move fairly quickly now and just give you some of the highlights.
Yep.
That about the EEOC and OSHA here.
I'll talk quickly about the EEOC. This is one area where we really don't have a lot of information on. It's a low priority on President Trump's agenda at this point. It already has a shoestring tight budget. But what we do know is that he's going to be able to fill approximately 3 key positions at the EEOC within his first 6 months of being in office. He's going to be able to fill the general counsel position, 1 vacant seat on the commission, and former chair Jenny Yang's term expires July 1st, 2017. So that would shift the balance 3-2 in favor of likely a more conservative pro-employer commission. We also know that the EEOC priorities under Obama had previously focused on pay equity and prosecuting discrimination claims based on gender identity and sexual orientation. We can expect a dramatic shift away from those 2 focus areas, but like I said, it's likely going to be a while before we see any real substantive changes at the commission. And so just a quick overview of what we can expect. As I said, it's a low priority, but long term, the anticipated changes that we expect to see are less aggressive tactics and a decrease in vigorous enforcement. reforming the policy regarding what cases to file in federal court, basically who decides what. Under the previous administrations, a lot of enforcement discretion was left to regional offices. It's likely going to be placed back in the hands of the general counsel. We're going to see a shift, like a likely shift of funds towards mediation as opposed to investigation and enforcement. Just basically a shift in resources and the focus there. We're also going to anticipate a change in EEOC's views on gender and